Mic check. Hello. Namaskar and warm greetings to everyone. I am Ashish Padam, counsel at the India International Arbitration Centre, which is the first and only statutory arbitration centre in India established by an Act of Parliament, an important milestone in our country's journey towards strengthening dispute resolution and becoming a global hub for arbitration. On behalf of IIAC, it is my pleasure to welcome you all to today's webinar. The theme for today's webinar is Institutional Arbitration and Appropriate Dispute Mechanism, which is being organized in collaboration with the Federation of Indian Export Organizations, FIEO. Through this webinar, IIC seeks to shed light on the challenges faced by the exporters and emphasize the growing significance of institutional arbitration in resolving commercial disputes effectively. We are also deeply grateful to our distinguished panelists who have graciously agreed to be with us today and share their insights and expertise. We eagerly look forward to the perspectives they will offer. And now, without taking any further time, let me introduce you to our esteemed panelists for this session. We have with us Honorable Mr. Justice Hemant Gupta. Justice Gupta is a former Supreme Court judge and presently chairperson of the India International Arbitration Centre. Justice Gupta has made significant contributions to India's legal and judicial landscape. With a judicial career spanning over 2 decades, he delivered landmark judgments in civil, contract, and arbitration law. At IIAC, he is dedicated to advancing institutional arbitration in India. His legacy includes judicial reforms, arbitration development, and modernization of the court system, making him a key figure in shaping India's dispute resolution framework. It is our honor to welcome you, sir. Next, we have with us Mr. Gaurav Banerjee. Mr. Banerjee is a senior advocate practicing primarily in the Supreme Court of India and specializes in domestic and international arbitration. He has appeared in several high-stake and complex matters, including commercial and investment treaty arbitrations. He is presently a national correspondent of India for the UNCITRAL Cloud System and vice chairman of the UNCITRAL National Coordination Committee for India. We are grateful for your august presence, sir. Moving further, we have with us Mr. Gohar Mirza, partner Saraf and Partners. He is a seasoned practitioner and has experience in handling arbitrations under different institutional rules such as ICC, CIAC, CIAC, LCIA, and ICA. His familiarity with these institutions allow him to navigate complex arbitrations effectively. We welcome you, sir. Next, we have Ms. Mumtaz Bhalla. Ms. Bhalla is a partner in the litigation, arbitration, and dispute resolution practice at ELP. She is an advocate on record with the Honorable Supreme Court of India. With over 17 years of experience, she has built a robust practice focused on domestic and international arbitration. She has been recognized by Forbes India's list top 100 lawyers and has also been acknowledged among the 40 under 40 legal achievers by BW Legal World. Great to have you, ma'am. Next, we have with us Mr. Raj Kamal. He is the director with the DGFT. He is a former civil servant of 1989 batch. He has held various important posts such as Joint GDFT, DGFT, Director FT, GS level officer, Regional JD GFT, Kanpur North Zone, and the list goes on. He has even represented India in the UNO body as a diplomat. It's a pleasure to have you, sir. Lastly, we have with us Mr. Abhishek Gupta, who will also be the moderator for today's webinar. He is a distinguished advocate specializing in arbitration, commercial disputes, amongst others. He regularly appears before the Supreme Court of India, Delhi High Court, and various tribunals. He is presently the Central Government Standing Counsel for the Union of India before the Delhi High Court and Group A Panel Counsel before the Supreme Court. He is also empaneled with various PSUs like ONGC, GAIL, BPCL, amongst others. Great to have you, Mr. Gupta. You are in the driver's seat today for today's webinar. For the audience, we would just like to say that if you have any questions, you can just put in the chat box, which will be taken up at the appropriate time. I think over to you, Mr. Gupta. The floor is all yours.
For extending me this warm welcome and for giving me this opportunity of moderating a seminal discussion on leveraging institutional arbitration for resolution of cross-border disputes. The topic for the webinar today reads, Institutional Arbitration, an Appropriate Dispute Resolution Mechanism. I really hope that by the end of this discussion, we are able to convince our viewers that institutional arbitration is also an appropriate dispute resolution mechanism for resolving cross-border disputes and for resolving the disputes of the exporters. And to facilitate this, we have this illustrious and stellar panel of distinguished speakers from different dimensions of dispute resolution ecosystem. I would like to start with Justice Gupta, who has had a long career as a lawyer, as a judge, and now as an arbitrator, and he presently heads the India International Arbitration Centre. Sir, can you shed some light on the importance, on the significance of a dispute, of an effective dispute resolution mechanism for exporters and for traders? Over to you, sir.
I think arbitration or alternative dispute resolution is important for all commercial establishments, more so for exporters, because exporters don't have any other forum except to go in for arbitration. You know, in Indian commercial entities can seek their dispute resolution from the ordinary courts, but exporters have no option but to seek arbitration, as the dispute between two entities, cross-border entities, can be resolved only by a negotiated settlement by way of an arbitration. You know, if we are looking for settlement by an arbitration, we have to look into the institutions or the ad hoc arbitrators which decide that dispute. Unfortunately, in India, the primary mode of dispute resolution is ad hoc arbitration. That is not the appropriate or effective way of dispute resolution, as the ad hoc arbitration has many limitations, including there is no cap on time, no cap on fee, and the hearings are also wide and spread over, which ultimately affects the efficacy of arbitration. On the other hand, the institutional arbitration have a predetermined fee, have a timeline to decide the disputes, and also that there is inherent mechanism to correct any mistake if it happens during the course of events. In our regulations, we have a clause that on the after the pleadings are complete, the calendar would be fixed, a timeline will be fixed, said that how much time each party will take, so that it can proceed to decide that this is one of the best practices of, in all international dispute resolution. But somehow or the other, in India, people don't follow it. We take everything for granted. I know as a matter of fact that if pleadings are to be filed before a Singapore International Arbitration Centre on, say, 25th of September, it has to be filed on or before 11:59. It can't be filed the next day. That time is so important. But as our nature is, so we are quite relaxed about time, and invariably people ask for, say, give me 1 week time, 2 weeks time to complete my pleadings. I could not do it for one reason or other reason. That is not accepted in international forums. We should have the best practices. Why the other jurisdictions are more popular? Because of the strictness in the timeline. Therefore, my view is that we should have a strict timeline for completion of pleadings, for leading of evidence, and for arguments. And after all that, once the draft award is shared with the institution should also look into the award, the clerical or arithmetical mistakes, which are actually very important. I remember in one of the award which was given by an arbitrator, a sole arbitrator before our institution, the award was full of more mistakes than the correct lines. So we have to struggle quite a bit to remove the defects. If such an award had gone to the court would have set aside it without even second. It was something like that in one of the judgments. Actually one particular judge who was transferred to my parent high court, his paragraphs will run into 2 pages. One paragraph will run to 2 pages or 3 pages. One has to really struggle what he wants to say, comma, colon, and other things. So Supreme Court has commented upon his orders that these orders don't make intelligent reading. So we have to, that is the advantage of institutional arbitration, where these things are taken care of. Another thing which I want to say is, from our institution is almost 3 years old. We have multiple awareness programs. In fact, I met Mumtaz Bhalla in one of the earliest interaction, which was meant for the legal firms. So I had no idea who she is. She walked up to me and said that, I had appeared before you in one of the cases. I had no idea. But, that was one interaction. Then we had an interaction with the standing or the general councils of public sector undertakings, and then general councils of all institutions, corporate bodies. These are awareness programs. The exporters had taken a backstage, but we didn't want to miss out the exporters, to make them aware of the institutional arbitration, and that is the purpose we are here today. With these words, I will leave Abhishek to ask another question or to ask another speaker.
Thank you, sir. Thank you for setting the tone of the webinar and your candid views on ad hoc arbitration and institutional arbitration. Indeed, institutional arbitration is the need of the hour and has to be adopted wide scale by all the people. Now we move to Mr. Gaurav Banerjee. He's a senior advocate of the Supreme Court of India. He regularly conducts arbitrations as counsel, as arbitrator, and I believe we would require more than a session to talk about his achievements and experiences. In short, he is synonymous with arbitration in India. So, sir, what are the common challenges and roadblocks, according to you, in cross-border resolution of disputes? And how far has arbitration or institutional arbitration been effective in ironing out these disputes, in ironing out these differences, and in assuaging the concerns of the stakeholders?
Thank you, Abhishek, for that very flattering introduction, but be that as it may, I think let me first enumerate the challenges, and I think then there are other people here who will give you the solutions, but senior lawyers always create problems, so let me what are the challenges? So you are an exporter. What are the aspects that you would want to look at? One aspect would be that you are based in India, you are doing business with a foreign company or a foreign party. First issue would be what we would legally say is jurisdictional. Which is that law which is going to apply? Is it going to be Indian law? Is it going to be that other country's law? If there is a dispute, where will you go? Will you go to their court? That can't suit you. Will you come to Indian courts? That will not suit them. So usually one arrives in an international arbitration scenario where you agree to arbitration. I'll come back to this. I think this is a very important aspect that exporters would be looking at. Of course, the first thing is, in 99.9% of cases, hopefully there will be no dispute. But unfortunately, disputes happen, and then some issues arise. One is, of course, you will not contemplate a dispute arises. There is an issue of, obviously, of cost, how much it will cost to actually get your money out or to defend the dispute. What about the delay? After all, you are in business, you are not really interested in legal niceties, so delay is a major factor. Then, supposing you get a good order, how will you enforce it? How will you recover your money from somebody abroad? And last but not least, all this is good, but sometimes we perceive that there is a power imbalance between some exporters and some big parties abroad. So these are some of the challenges, and I will volunteer some solutions, but I'm sure my other speakers will say more. And I'll give you an example of what happens if you don't look at this at the beginning. Obviously, one critical aspect is to agree that if there is a dispute, where will you go? Normally, the foreign party wants international arbitration sometimes outside India. And if the power imbalance is such, you may collapse and you may not agree, and you may be forced to go outside and have your arbitration outside. But now you can pitch the fact that you have a statutory body which is recognized by the government of India as the institution of national importance. And certainly I think now the balance of power has shifted, and you can insist that the arbitration should be here, and it is obvious that it has to be an institutional arbitration, because ad hoc arbitration has been shown to be high costs and delays. So I think that is pretty obvious. So far as enforcement is concerned, if you get an award from, say, IIAC, you can take it in 162 countries around the world and you can enforce it under New York Convention. So that should not be a problem. So I think there are challenges, but the answer to the challenge is to sort it out at the stage of entering into the contract. So I'll just give you one example and I'll hand back to Abhishek. Just maybe 1 month ago, I was appearing before the Supreme Court in a case called Glencore and Sri Balaji. It was a dispute which involved certain supply of some metal ore. So Glencore is a very well-known trader in metals worldwide, London Metal Exchange. And Sri Balaji and Glencore had entered into a series of contracts, and there was no problem. until there was a problem, there was some difference of opinion, Sri Balaji had not signed the agreement, and though they thought they were safe. But in fact, the agreement mentioned LCIA clause in London. So ultimately, at the end of the day, Sri Balaji was driven. I appeared for Glencoe. We managed to succeed in the Supreme Court, and Sri Balaji was driven to go and make a claim in the LCIA in London under English law. All this problem would have been avoided if at the very first stage you had negotiated a clause with Indian law, with the IIAC. You will be in a better position to avoid high costs, delay, enforcement, and fundamental issues like English law, this law, the other law. Of course, this is subject to any power imbalance. I think by way of opening remarks there, I have highlighted sufficient challenges.
Thank you so much, sir. Thank you for your enlightening views. And I can say it as a matter of fact, Glencore is an international Swiss company, and they swear by sir's name. And this is in a different context, which I'll talk to sir later. So we have heard Justice Gupta, we have heard Mr. Banerjee, and Justice Gupta is championing the cause of institutional arbitration. And we are all grateful because he is single-handedly spearheading the cause of institutional arbitration in India. Now, coming to Mr. Raj Kamal, sir has held many coveted posts in the government of India. And being in DGFT, I'm sure he must have faced with issues of the exporters and importers alike. So, sir, what are the common problems and issues which are faced by exporters? And is there any kind of grievance redressal mechanism in DGFT? And how can institutional arbitration or how can institutes like IIAC complement this dispute resolution at DGFT?
Thank you very much that you have given this opportunity to explain. Although I have left the DGFT for long back, I have been posted there as a additional Director General Foreign Trade, joined DGFT. And fortunately, I have handled this grievance redressal committee in import-export policy. There was a provision for the grievance redressal mechanism. So, I mean, the exporter, if they have a problem, so they come to us in DGFT, they file their complaint. There's Mr. So-and-so, this company has not given my payment. But as a government of India, we have a jurisdictional problem because normally they don't listen. They don't listen. And we have to take the help of embassy, and we call the first secretary, first minister or ambassador, isn't it? This is the problem. So they approach the importer, they are a buyer in their country. So the lot of jurisdictional problem. And in my career, I have handled this 30, 40 cases. But there was solution is very nil, isn't it? I was representing the India in UN body that is called Kimberley process. So in Luanda, Angola. So De Beer is a very big mining company. So they come to me, and they were approximately 25 members. And from Government of India, you are alone. They will not give you the my director, my deputy secretary, they will not give the clearance. Only one man will go. Anyhow, I have discussed this with De Beer. So they have an agreement with the Madhya Pradesh government and Government of India. They have been allotted one mine in Bandar mines, if you are aware from Madhya Pradesh, near I think Panna district, there is a Bandar mines. So the Government of India has given for open mining, isn't it? They have started, they have spent 200 crore rupees. When the, the deal has mature, diamond निकलना शुरू हुआ, then the NGT, National Green Tribunal, they come to, in between that contact, you cannot do the open mining. You have to do underground mining. अब underground mining का उनका खर्चा बहुत था. So these are the dispute. ये तो जस्सा भी बताएंगे कि मतलब इसको कैसे मतलब क्या judgment कैसे. But we call there here in India and we discuss. We have visited the Bandar mines. I mean these type of like this, now they have created this body, Indian International Arbitration Centre. I hope, I wish कि इसमें काफ़ी कुछ वो involve हो. But what is the jurisdictional problem? Suppose most of the exporter has a problem, isn't it? So they have this agreement. When they supply the goods, so they have an agreement. So at that time, through councils, because they are a member of councils, some leather export council, some FIEO, some FICCI, some. So we can, means through this forum, we can approach them, the council, and jurisdiction में हम डाल सकते हैं कि if there is a problem, so they can come to this forum. So I think that will be binding also. एंड उनके दिमाग में भी रहेगा कि अगर कुछ है तो ये मतलब हमारा जो भी जजमेंट होगा वो बाइंडिंग होगा. एंड लाइक LC कंडीशन, लेटर ऑफ क्रेडिट, सो वी हैव गिव ईच एंड एवरीथिंग इन लेटर ऑफ क्रेडिट, हाउ द पेमेंट विल बी मेड, हाउ द गुड्स विल बी मेड, हाउ द इंस्पेक्शन कैरिड आउट, international inspection carried out. So, we can use this forum for this. And मुझे तो कुछ यही समझ में आ रहा है. बाकी अगर कोई any questions, so I can this.
Thank you, sir. Thank you so much for your practical suggestions and your endorsement of IIAC as an institute. Now coming to Ms. Mamtaz Balla, who is a partner in the dispute resolution practice at Economics Law Practice. Ma'am has made immense contribution to the growth and development of dispute resolution practice in India, and she is currently the Vice Chairman of Society of Indian Law Firms. So, ma'am, I have some concerns of the exporters for you, because I'm just thinking from the point of view of an exporter. So many a time, there is an exporter who is at loggerheads with a foreign buyer or a foreign party. And that foreign buyer or a party may not be covered under a beneficial legislation like MSMED Act, or may not agree for an arbitration clause in the agreement, or may not agree for the seat of arbitration to be in India. So in such situations, what steps or what safeguards can be adopted by the exporters? And how do we assuage these concerns of the exporters, which are quite genuine according to me? So ma'am, your views.
Thank you, Abhishek. Thank you to everyone for their views. I've spent more than 17 years in the profession, and trust me, when I entered into the arbitration practice arena, we only heard of ad hoc arbitrations. Great push has come in the last 2-3 years. Senior counsel Gaurav sir and Justice Gupta. Justice Gupta has actually seen the challenges that have come to all the way up to Supreme Court. Our Supreme Court has been very, very vocal in non-interference and giving full regard to party autonomy. But then what happens when a trader is negotiating a deal, they want to sell their products, they want to export a product out of India. And like Abhishek has said, there is no push from their side to agree to a neutral venue or India as a seat of arbitration. We have to also understand that this baggage that comes in is because of the past conduct, which is why there has been a great deal of push towards institutional arbitration because of the transparency, the certainty, the cost efficiency, and the lack of bias it brings in. if I am to advise an exporter, because when you talk to a trader, they don't care what the law is. You tell them, oh, this law is favoring you, and they're like, I don't care about the law. I want to see the color of money. When am I getting my money back? So when a agreement is drafted, I think the best suggestion would be to have security clauses in place, like Sir had suggested. A letter of credit or a bank guarantee or a trade insurance as a backup plan. Trade insurance is anyways very onerous, so the party should take that, but a security clause by way of a bank guarantee or a letter of credit should be there. Because when you're exporting something which involves a foreign party, like Justice Gupta had said, you enter into a jurisdictional challenge unless you have a clear-cut arbitration clause. And Senior Counsel Mr. Banerjee is right when he says that if you have a clause in place, you have enforcement in more than 162 countries. And it's easy. You get an award and you enforce it. If you have no clause in place, you get entangled into those procedural aspects of appointment of an which court to go to. If it's a country like India, you have original jurisdiction in 4 courts, but you have no original jurisdiction in different courts. Some parties are not even comfortable going to district courts, and I'm talking about foreign exporters also, foreign importers also. When they have a dispute, they tell us that no, we don't want to go into a district court. Is there a way we can bring in a jurisdiction? And again, your commercial courts are good for people here, but when you're dealing with a foreign party, initially, there was some cloud surrounding the MSME Act, where people felt that if there's a contract with an MSME trader, you can straight away bring in the statutory protection, and you can, because the services have been rendered in India, you can bring in an MSME arbitration. But very recently, the Supreme Court has left that issue open, saying that we need to examine whether a foreign party can be made subject to an Indian statutory law when they have not submitted to Indian law in the first place. So the step of securing themselves begin at the stage of drafting a contract. While nobody may agree to an MSME arbitration, but you don't need an arbitration clause under MSME. It's a statutory arbitration. Even if the clause is not there, you can invoke it if you fall within the ambit. But greater push should be there to have an institutional arbitration mechanism in place. When you tell a foreign party that, okay, I'm not getting into the ad hoc arbitration concept of India, where you have to run to different courts for appointment of an arbitrator and then challenge to an arbitrator, we are getting into an institution, and IIAC rules are pretty much in line with the rules of whether you take your MCIA, CIAC, ICC, bearing a couple of changes here and there. The principal fundamental genesis is the same. So great push should be given to have a neutral institution which is not going to be biased either ways and constitutes experts. But if the party is not agreeable at all, then the subject matter of the contract should definitely be secured. Sir had spoken about the ministries of the other government responding. Now, that is the problem with, that comes in. DGFT has been very, very efficient in referring disputes. But once something happens here, unless a party submits to an arbitral institution, if you go through the regular process, you will never hear from the embassy of the other country. It will delay, and then the trader is going to come and tell you that, where's my money? So the twofold safeguards that I feel are securing the subject matter, trade insurance on one hand, and insisting on a institutional arbitration mechanism as a mandatory requirement.
Thank you, ma'am. Thank you for addressing the concerns of the exporters and our audience. Now, last but not the least, we have Mr. Gauhar Mirza, who at least until yesterday was a partner at Saraf and Saraf, considering he has worked across so many law firms and has earned many accolades and recognitions on the way. He's definitely a force to reckon with and a voice to be heard. So, Gauhar, I'm particularly intrigued by the role of institutions in dispute resolution for exporters and for traders. And how can institutions like IIAC contribute? See, because many of these exporters, they are micro, small players who may not have the wherewithal to actually pursue a costly arbitration. So how can we incentivize or economize the cost of dispute resolution for them?
So thank you, Abhishek, for that question. And taking a small cue from what Mumtaz was saying, that the beauty of IIAC, at least in the model clause, if you see, is, like Sir also mentioned, that it has an applicability across 162 countries, nations across. So if you see the model clause, everything else is not changeable, but the seat is changeable. So that is the one flexibility that IIAC offers. The model clause is available on the website also, you can see. But the question that Abhishek has put is, what happens when there is a MSME related issue or a small organization which is not able to afford an expensive mechanism to get their dispute resolved. So IIAC has a specific MSME related rule that is in place. Firstly, it is cost efficient. Second, it also offers feasibility of access, whether it can be joining through ODR, on online dispute resolution mechanism, and the timelines are fixed. Like Justice Gupta, when he started by saying that when we look at IIAC or any other institution internationally, we see that timelines are the only thing that they are particular about. In India, we have slightly some relaxations, or we take it slightly easier in India, and we on the night of filing we send an email saying that please give me two more weeks. IIAC is obviously trying to bring in that difference in the approach that we have, at least by way of implementing these measures into the system. That is one. Two is educating people. Like today, we are sitting on a Wednesday evening having Mr. Banerjee, Justice Gupta. We are trying to educate people more into how you have to come towards ADR, how you have to come towards these facilities which are available. The model clause, if you can just review, I just reviewed it because Vinay asked me to also review it before coming in. So I saw it and I've seen it. It is akin to what an international arbitration institution would have. So that is the beauty of IIAC. Now, cost efficiency, and rather, if I can take the permission of my learned seniors here, I have coined a term called FERE. It's called FERE. Hindi में गोल गोल घूमना, किसी चीज़ के आसपास घूमना. What is arbitration? In my view, arbitration is running around a problem just to find an award which will pay up and be enforced. Now, what is FERE? What I have coined, and rather is the first time I'm telling this to someone, is fast, economic, recovery oriented and enforceable. That has to be the crux of what your award has to be. Mr. Banerjee mentioned about a judgment of Glencore. I will just remind him of 2020, a judgment of Glencore versus Hindustan Zinc, which he argued before the Delhi High Court. I say it because I'm going to rely on it tomorrow morning in a supplementary matter before the same judge. The problem and the solution in 2020, and we are in 2025, 5 years. Mr. Banerjee argued that what is an award is money, right? What is jurisdiction? Money has no jurisdiction. If a party is in Uttarakhand and you file a foreign award enforceability in enforcement petition in India, money will not have jurisdiction. And that is going to be my argument, which was his argument, rather that matter later on got settled. But we have to understand that the enforceability has to be seen in two steps. What we see as enforceability is, where are the assets of the party? Why don't we see that, why can't they pay up? In a foreign award situation, parties usually write to the other party, come on, give me the money. In India, we don't have that concept. In India, we have the concept of how much is the stamp duty, how much are we going to pay to get it enforced. So I think the sensitivity towards enforceability has to increase. The sensitivity towards cost efficiency has to increase, and FERE, and I will request Justice Gupta to see this term and try to take it forward, if possible, by whatever means he can, to see if FERE can be achieved.
Thank you so
Abhishek,
much.
I would just add on to what he said, how an independent neutral institution also helps you is enforcement. If you don't have assets here with a foreign party, what will you do with an order that you get here anyways? If you get an enforcement in 162 countries, it just narrows down because they have assets there. I tell everyone that, when you getting an order is the easiest part. What do you do with that order? You fly a kite out of it. You need to enforce that order because ultimately the client wants the money. And when you have a neutral institution that parties have willingly agreed to, there's very less chance for them to wriggle out of that and get into a procedural, challenge. And you can enforce it where they are present, where their assets are present. And it becomes a quick and a more expeditious exercise. Thank you.
Thank you. Thank you, Gohar, for a very compelling case for institutional arbitrations. And you can surely rely on that Hindustan Zinc unless Swaraj got it distinguished in some other case.
I did my research.
Now coming to Justice Gupta. So one question, because we are here talking about cross-border disputes. Now, of course, we may have a foreign party which may insist for a foreign arbitral institution. So what are the comparable advantages of IIAC when we contrast it with CIAC, ICC, and what benefits does IIAC offer?
No, basic problem is we have, I would say, inferiority complex. We don't agree that Indian institutions can be good. We like something which is foreign. That mindset has to change. Our exporters should insist that India has better facilities, better talent than any of the countries. We have to have confidence in ourselves. We don't believe in ourselves. We believe in others. And that confidence has to bring in to say that we are competent, we are efficient, we can deal with all kind of disputes in a more efficient way than the other foreign institutions. But that confidence will come only after they believe in the institution. Somebody comes to us that how we conduct the proceedings, only then somebody can. I give you an example. The lawyers can't advertise that they are good lawyers or bad lawyers. But it is the client who advertises. If they say, the client would say that I engaged so-and-so lawyer, he has done good job. The same way the litigating, disputing parties, if they come to us, they will advertise ourselves. So that it will take some time, but our advertisement can be only by, one of the suggestions given to us was, why should not we advertise in the newspaper? I'm not very sure whether we can do that or not, but otherwise also nobody comes with the advertisements. People have to have confidence in the justice delivery system, only then people will come. Advertisement is, you can have a satisfaction that we have inserted so many advertisements. I won't say, in Punjab you will find full page advertisement. We have, a school of excellence and so and so, but ground level is zero. You can have a satisfaction that you have done so much in the newspaper. That is a newspaper, akhbari hai. That's all I would like.
Thank you so much, sir.
Excuse me. Actually, we have to approach the export promotion councils, because we cannot tell to every exporter that you do like this, because export promotion councils, they have a budget also. The government of India, Ministry of Commerce have this huge budget. They distribute or they give this budget and they spend through the councils. And every exporter is a member of the councils. And when the buyer-seller meet, so at that time, they can mention this class and they can mention this IIAC. IIAC के बारे में खुद ही पता चल जाएगा उनको एक आध साल में कि what they are doing, isn't it? So वो अपने आप ही प्रचार हो जाएगा. But we have to mention this. And there is an agreement clause when the buyer-seller this meet and they dispose of their this product. So, and there is a LC clause. Insurance clause is already there, because without the insurance, the LC is not a problem. LC is a problem. So the letter of credit, everything is there. I mean, we can approach the bank and we can mention this IIAC. कि अगर कोई dispute होता है तो आप IIAC के through आप आइए. And when the both party will sign, the automatic jurisdictional clause will not be a problem. This is my suggestion.
Just a word. There is an export council. In fact, today's conference is at the instance of export council only. Mr. Rakesh Sharma is the one who is looking after export council. he suggested that we should have interaction.
Yes, that's good.
And that's why we are having it.
Yes, yes.
And
Apple Promotion Council से हैं आप, हाँ? Yes.
and actually, your name was also suggested by Mr.
अच्छा,
Rakesh
अच्छा,
Sharma.
okay.
We had no idea because he was the
I have
one.
never met, but we have talked so many times. Yeah.
So we are trying to do whatever way we can reach to the real sufferer.
No, sir, we will
That's-
got the result. It will be actually it is result oriented.
Yes, yes, it will happen. It will happen. I am confident it will happen.
And
but
when
it
you
will
have
take time.
started this thing, and I think time lagega, but the result will come.
That's I am confident about it.
Thank you,
Yes,
sir.
Abhishek.
I have one question for Mr. Banerjee here. So we've seen the Arbitration Act. It provides a certain leeway for international commercial arbitrations. The courts are different. There is reduced scope of interference, no patent illegality. There is quicker enforcement, and even the petitions for appointments go to the Supreme Court. So what other statutory amendments can you conceive of to make it more attractive?
That's a very sensitive topic. I've been part of the Vishwanathan committee. We've given a report, but let me turn your question around and look at it from the the exporter point of view. I think they should know this, that in the disputes that they will be referring to an arbitration, it will be an international commercial arbitration because the exporter is from abroad. So in that event, if you have an award from, say, IIAC, then one great fear of any citizen of the country, with due respect to the Honorable Chairman, is everybody is scared of the courts. They will get an excellent award from IIAC.
No, they should be scared of you.
Lawyers, absolutely. So they get an excellent award from IIAC, and then there is obviously challenge and you get sucked up into it. But we have designed the arbitration law in such a way that for international commercial arbitration, which is what this will be, then the interference is much less than in a domestic case. So I think even if it is challenged, and if you have a good case and you have a good award from a reputed institution like IIAC, then you will be able to navigate even the court system and be able to get out your money. Obviously, there are two situations. One is the foreign party is business-wise stronger than you. Then they may insist for a foreign jurisdiction. That's an economic reality. But now if you are in a position to insist on an Indian jurisdiction, then just going to an Indian court will be a disaster.
Right.
So you will have to go for arbitration, and if you go for international commercial arbitration, you should go for an institution.
Right.
Why? Because this 162 number which I mentioned, there is something called New York Convention. You can take that award, walk into the US, walk into any country, and it's reasonably easy to get out your money. Say the exporter has sent some material outside, other party has run away. Then you get an ex parte award and you go and enforce it. So this system is quite good as long as you convince the other side that you should go for institutional arbitration.
Right. Thank you, sir. Gohar, what can you contribute to this, and what policy changes can you think of to streamline the process? And
See, I think when we increase enforceability, like we have a New York Convention and 162 countries are part of it, I think that is what is required at a ground level as well, even for domestic arbitrations, because right now we're talking about international, of course, right. We have to deal with an international party, so it's a foreign award which has to be enforced, which has slightly better value of enforcement rather than any domestic award. But let me give you a small statistics from our Delhi High Court. The last enforcement of foreign award that I had filed in 2015 September was the number 7th petition. Number 7 in 9 months. So you can understand either the fear or the less number of enforceability that is there I think that is what we have to work towards. The act, the amendment that can be suggested to the act can be that first you increase the confidence of internal stakeholders, domestic stakeholders, then take it out. I was hearing some speech by Justice Muralidhar last week during the arbitration week that was happening in Bombay and Delhi. And one important thing that he pointed out, and we all talk about it very casually, is that we have to really work towards putting our house in order. Right? Once you do that, automatically it will happen. A speech was made by, I recall Justice Gupta, in Singapore, or rather we were having a discussion where we saw that in 2003, when IIAC was only in the initial stages and they used to be the last one sitting and waiting for people to recognize them. Today we look up to them. I think IIAC has the capacity, capability, and people like Justice Gupta and mentors like Mr. Banerjee, that we can actually work towards it. So Mr. Banerjee has been part of n number of committees, and he has suggested we have to just see the actual practical execution of those strategies from a practitioner's perspective and from an exporter or a trader's perspective as to what they actually need. So I think that is my 2 bits on what can be slightly brought into the system.
Thank you, Gaur. Ma'am, one last question for you. See, it's quite possible to have a neutral venue while retaining the IIAC regulations. So, of course, because if a foreign party insists for any venue outside India, so that is always possible. But then, how far is the stage of negotiation of contracts? Because the dispute resolution clause, I think that's the last thing that comes to the minds of the parties when they are negotiating any contract. Was the first thing that you see when there is a dispute. So, what is the significance of negotiation at the time of inserting a dispute resolution clause, and what can the parties keep in mind?
Abhishek, trust me, the most important point is the dispute resolution clause. Everything else is negotiable. But I think, like Justice Gupta said, it's an inferiority complex. Ultimately, negotiations happen between lawyers. It is incumbent upon the lawyers to advise the client right. You can have a neutral venue, you can still have IIAC, and the way you convince the other party is that, okay, it's not me, it's not my choice, it's not your choice. Let's have an institution which is more preferable to a contract of this nature, because if you go to a CIAC or ICC, the fees is much higher and the rules are almost the same. You have a provision of an emergency arbitration, you have a fast track procedure, you have a witness, an expert witness process. Even if the other party does not bring in an expert witness, if the tribunal feels they can bring in all those. So when you compare an appointment fees of a $5,000 to a $75,000, a $15,000 to lakhs of dollars, it's just an easy negotiation power. It has to be done in the right way and for the right reasons. If the fight is on moving from courts to arbitration, it's a no-brainer. I don't think there is any party, whether Indian or international, which would prefer going to your commercial courts here, even if it is out of choice, because no matter, your commercial courts have expedited the process, but it is only up till the stage of written statement, your 120-day clock, and then it's done. Then what happens to your evidence? Like Justice Gupta said, if it's a CIAC arbitration, and it's true, I'm telling you, across law firms also, I've seen people, if it's a foreign institution, they will think 5 times before seeking extension of time. They will have robust reasons. If they file an application for extension of time, they will have, a detailed reasoning and backing up documents. But if you need time here from an ad hoc tribunal, you will just write that we need 4 weeks, and you will get 4 weeks. So the idea behind this is to not distinguish the challenge between courts and arbitration. It is to explain the other side, that while you may be okay going into an CIAC, ICC, I am okay with the law of that place, the seat, but I need to have a neutral institution which is more affordable, because not all contracts are financially viable for an CIAC and ICC arbitration, and that is how you take it to an international level from arbitration by arbitration. And they say the reward for good work is more work. So that's the best form of marketing for anyone. So those are my 2 cents.
Thank you, ma'am. I thank all the panelists for their candid, honest views and for enlightening the audience. Ashish, any questions from the audience?
So in fact, we have quite a few questions, sir. So the first question is to Justice Gupta. Sir, the question is, what can India really do to make India a hub for arbitration like IIAC or LCIA?
The first thing is that we should have confidence in ourselves. We should have confidence in our institutions. We should resort to institutional arbitration in India. That will be the first step. Everything else will follow.
Thank you, sir. We have another question for Ms. Bhalla. The question is, what specific challenges in international trade disputes can institutional arbitration help resolve more effectively than litigation?
There are many, but I think the primary would be getting a tribunal in place. I feel, like I said, you may have a commercial court, you may have a fast track court. You have to understand the pendency of cases in courts in India, and it's very hard for traders here to go and litigate abroad. So arbitration gives that alternative because it gives an option of exploring mediation before, whether if you want. If you don't want a mediation clause to be put in, you don't want a MEDAB also to be put in, you have an arbitration mechanism where you don't have to go to a court for appointment of an arbitrator like it was just pointed out in an international commercial arbitration, you need to get to the Supreme Court for appointment of an arbitrator. So it's because of the sanctity the contract brings in, but then the process of appointment of an arbitrator gets extended for 3 to 6 months, even if it is very expedited. We've seen increasingly courts saying that, there's no reply required in the Section 11. If you are agreeing to the arbitration agreement, why don't we appoint an arbitrator? But we are lawyers, we are very smart people. If we don't want appointment, we know how we make the replies and how we object to it. So I think the best benefit that a party gets out of it is that 6 months procedure to even initiate a dispute gets shortened. You have an institution, you write to the registrar of the institution, or you raise a claim online. They will, if it's an MSME referred arbitration, you have a sole arbitrator. Whatever your contract says, it doesn't take away your arbitration contract otherwise as well. If there's a 3-member, you nominate yours, the chairman appoints the third one in consultation with the advisory council. That process gets completed in a very short span of time, and there's certainty attached to it. You don't keep running to court that, this appointment is wrong, this agreement is not arbitrable. And then if there is a bias, the biggest challenge as lawyers we feel is when we have an ad hoc arbitration, who hears the challenge to the bias? It's the same very tribunal. You don't want to do that. When you have an institutional arbitration, if you feel that something is not being very transparent, you bring in the material and the institution is very happy to take. If the other side is agreeable, they will do it without any consultation. But if there are reasonable reasons, it's just more easy. So I feel that if I have to advise a client, I will tell them that it's a quicker process. You get into a quicker remedy and your process gets kick-started quicker than it will if you don't go in for an institutional arbitration.
Thank you, ma'am.
Just one. There is no parity in the process of appointment by an institution or by the court. According to court, it's a quasi-judicial function. So reasonings are required. Reasonings, of course, they say appeal is not maintainable. But for institution, it's an administrative order. So there is a conflict. How the institution, for an institution, it can be administrative order, for court, it can be quasi-judicial order. That's... I will leave it to Gaurav Banerjee and Gohar to raise it at an appropriate stage.
Thank you, sir. Another question is that how does IIAC ensure neutrality and fairness in cross-border disputes? How does IIAC ensure neutrality and fairness in cross-border disputes? So this is a general question. Anyone from the panel can answer.
So I think what is also important to see is that the panel of arbitrators that IIAC has, it ensures that there is obviously an element of neutrality. It is not that a particular arbitrator is being appointed for a particular zone or an area or a jurisdiction. So that is the first step. But of course, IIAC also takes care of the cultural differences that one may have. Because we have seen practically, and Mumtaz can correct me if I'm wrong, that an arbitration between an Indian party and a Japanese party, there has to be some cultural neutrality to be adopted. So I think when IIAC steps in, they take into consideration each and every aspect and then appoint the either the presiding or the sole arbitrator. So I think that is where slightly IIAC plays the role and a very important role in bringing in the neutrality aspect into arbitration.
And just to add to this, you don't get stuck. While they will choose arbitrators from the panel, but if it gets to a roadblock, there is an option to get an external person appointed as an arbitrator as well in very, very exceptional circumstances. So you're not going to fall foul of the rules. You're not going to get stuck in a long drawn process. There is a solution for everything because, like Sir said, it's an administrative process to be exercised judiciously, if I'm not wrong.
And I can just say that the fast-paced approach that Mumtaz is pointing out, and by way of statistics, to replace or substitute an arbitrator in ICC and CIAC, you can ask me from practical perspective, is the toughest thing ever than filing a Section 11 in the Delhi or the High Court or the Supreme Court. Substituting an arbitrator, for whatever reason, maybe the arbitrator has recused or there has been some issue of bias, etc., the substitution takes minimum of 3 months, minimum. And the cost attached to it is minimum 5,000 euros. So we have to be conscious of these things also, that how quickly are you getting a substitution? How quickly are you getting your appointment? How quickly the result is getting delivered? So those are the aspects that an institution like IIAC is bringing in.
Thank you, sir. In fact, we have another question perhaps Mr. Banerjee can answer. So the question is, how can industries and exporters be made aware about institutional arbitration mechanism when they themselves are already hesitant to go for ADR?
I think, that question assumes that they are hesitant to go for ADR. I don't think exporters are hesitant to go for ADR. I think they would rather go for ADR rather than either the domestic courts here or the domestic courts in the other country. I think the challenge at least is ad hoc versus institutional. And then there is, I think what is being done today is the solution, education as to how an institution such as IIAC can really assist you.
Thank you so much, sir. I think that was truly an insightful and enriching webinar. We sincerely thank all the panelists for sharing their valuable perspectives with us. We would now, may I please request Mr. Naveen Kumar Singh, CEO,